Can we give you a shovel or something? So, we're gonna spend the next half hour in workshop. It was a suggestion of Jennifer's, who is stuck in traffic, our city attorney, that we review. Since it is the start of the new year, we review our planning board rules of procedure, and this is mainly for us. So we'll just go through these. Obviously, if you have any questions, we'll sit and chat about it. But starting from the top, these are our City of Beacon Planning Board Rules of Procedure for Public Meetings. The City of Beacon Planning Board, this is number 1, shall hold its meetings on the second Tuesday of every month at 7:30 p.m., which may be immediately preceded by a work session at 7. We're pretty usually very good about this. The work sessions also, by the way, help fulfill our requirements as board members by the state for training hours, which is good to know. All of that unless otherwise posted and noticed in accordance with lawful requirements. Membership expectations. And if any of this is new to you, let me know if you have questions about it. Members are, this is item A, members are expected to attend all duly noticed meetings of the planning board. Randall. Randall also was re-upped. The longest serving member of the board in the city's history. Although I'm proud to say I'm second.
How many terms is it?
So I don't know. I don't know how you did, what is it, 3 years?
4
I
years.
have no idea what I just signed on
It's
for.
4 years. Yeah.
Is it 4?
Yeah. This is the beginning of my 6th.
Wow.
Yeah.
So I've been on the board as long as Randall, but Randall's been on longer, and I started in '03. So however many that is. Members shall notify the planning board secretary and the planning board chair of any expected absences as soon as practicable. All you are very good about that. Thank you. Members shall be familiar with all materials submitted to the planning board in connection with pending matters. Members shall be required to complete all training required by law in the City of Beacon City Council for service as a planning board member. And again,
Can I ask a question about that?
yeah.
Do we have to do additional to the workshops, or does the workshop suffice in our training requirements?
In my experience, the time we spend in training here has sufficed.
We get about 6 hours if we attend if we don't miss
Right,
any meetings.
during the,
Right, and I think you need
Year.
a total of 4 hours.
Okay.
yeah, yeah. So it's, I think Mercedes sort of loosely keeps track, right?
There was some,
It's in the minutes.
Yeah.
Training.
a couple of years ago, there was a question about whether we needed to take other trainings that city employees took, but my recollection is that it was determined that we do not have to take other trainings.
Yep.
So,
Does that answer your question?
Yeah.
So we're good. Let's see. Members are expected to be familiar with Chapter 45, Planning Board and Zoning Board of Appeals, Chapter 86, Architectural Design, Chapter 107, Environmental Quality Review, Chapter 123, Flood Damage Prevention, Chapter 134, Historic Preservation, Chapter 170, Public Trail Regulations, Chapter 183, Signs, Chapter 190, I want to read all these, yeah, 191, 195, there she is. 204, 220, and 223, the comprehensive plan and other plans, reports, and statutes as are necessary for a member to responsibly discharge their duties. And all of this material, obviously, is available on our city's website. What is this? Subnote 1. Rules of procedure are adopted pursuant to Section 40, and are in addition to any requirements imposed upon the chairperson. This is the part I like. All shall hail and bow. No. The executive officer of the planning board is the chairperson as designated by the mayor pursuant to Section 45-5 of the city code. The chairperson shall have the responsibilities and authority as specified herein and in the City of Beacon Code and State of New York City General City Law preside at all meetings and hearings of the planning board, sign all approved final plat, site plans, and permit approvals issued by the planning board, sign all instruments made and approved by the planning board, perform any other such duties as may from time to time be required. That's kind of loose. And call special meetings of the planning board as provided herein. We don't often call special meetings of the planning board. I don't recall many in my tenure. What type of special meetings do
It says as provided herein, which is some examples.
Yeah,
of when
I was gonna say.
Special, no, like, for example,
We did a site visit.
Yeah.
yeah, site visit isn't necessarily a meeting, though, and there's a whole section on that. We can talk about that. No, I mean, if there's a particular time constraint with respect to an action that needs to be taken, sometimes you'll schedule a meeting not on the second Tuesday of the month. So there's a variety of different reasons why you might need to call an extra meeting.
Everything okay? You
No,
made it
there
here.
was a bad accident on the Taconic just
Yeah,
before you
Mercedes
cross over
mentioned.
into Dutchess.
I'm glad you
So
got
I
here okay.
snagged in that.
Let's see, where were we? Guidelines for planning board members. Actually, I don't know if I mentioned, but, oh, you know, yeah, Donna has resigned, so as of, she's not here tonight, but as of February, we'll be down a board member. So we may have to do this again.
Great. So she will be here in February? or
No.
No. Okay.
Yeah, she's
Okay.
done. And of course, the search is on. Let's see, guidelines. A planning board member must be recognized by the presiding officer before speaking and/or making a motion. A member shall address the chair and shall wait to be recognized. I'm looking at you, Lynn.
You need a gavel. Out of order.
I feel the weird pressure of your eyeballs on me.
Love you. Conflict of interest. A member prevented from participating in a matter due to a conflict of interest shall immediately inform the chairperson. Good evening. Happy New Year. Planning board secretary and planning board attorney of such conflict and shall not receive materials pertaining to the matter and shall leave the planning board table during discussion. Shall not vote on the matter and shall otherwise comply with state law and city ordinances concerning conflicts of interest.
And we recommend even a step further, not only leave the table, but the planning board members should leave the room.
Yeah.
Altogether.
And we then have to just remember to call them back. Non-disclosure of confidential information. No planning board member may disclose confidential information. This one's rather long. I'm not going to read the whole thing. Obviously, this is,
I imagine we will be told specifically when we are about to receive
Yeah,
confidential information.
was-
So that we
you know-
know
Yeah.
that it's
here, this is good. Confidential information means specific information rather than generalized knowledge received by a member as a result of his position that is not available to the general public on request. 99.9% of the information that we handle here is obviously publicly recorded, both on video, in notes, and on the city's website. So I honestly can't think of a time when there's ever been anything
I was
sensitive enough.
Reviewing these rules earlier today in preparation for this work session, and I was trying to come up with an example.
What if there was litigation?
There's-
Yeah, I mean, and that's attorney-client privilege, so that's, in a way, that's confidential information.
There are times when we go into executive counsel,
Yeah,
and those are attorney-client privilege conversations between the city, the board,
Yeah.
and the city's attorney. So to some degree, those conversations are confidential. But again, I can't remember the last time we went to the executive
As far as,
council.
like, information involving an application itself, there's really,
Rare.
everything is public, it's all publicly available, so there's really,
And you have to be told when you're about to receive
Yeah.
yes.
confidential information. So,
Usually it says confidential, attorney-client privileged, right? Let's see. Is there anything else about that we need to cover? Non-disclosure of confidential info? Meetings, open meetings law. All meetings of the planning board, except for meetings with its attorneys for the purpose of attorney-client communications, will comply with the requirements of the open meetings law, Article 7 of the Public Officers Law. Executive sessions may be held when authorized pursuant to Section 105 of the Public Officers Law or for other lawful purpose, including without limitation attorney-client communication.
Yeah,
And
so-
again, yeah, go ahead.
Yeah,
You
so
may want to
Section
drill into this
105
one.
has a whole list of permissible reasons why you can go into closed executive session where the public is not allowed to attend. There's a lot that are not relevant to the planning board that would be more relevant to city council proceedings, but things like personnel, things like litigation, discussion of litigation, and then attorney-client conversations are exempt from the open meetings law altogether. So, for example, we could have a meeting of a quorum of the board with me to discuss attorney-client issues without even noticing to the public, frankly. It's completely
okay.
exempt from the open meetings law.
As long as you're present.
Yes, yes. As long as I'm present and it's,
Yeah.
it's a discussion privilege with your attorney, yes.
Yeah, and again, one of the nuances of open meetings law is like site meetings. If we're all together and we are a
Yes.
quorum, that constitutes the requirement for open meetings.
If you discuss
If we discuss
business.
business.
Right, so that's the thing with site visits. Typically, we don't publicly notice site visits because the purpose of a site visit, when you're there, even if there's a quorum of you there, you're there to observe, you're there to collect factual information. You could ask questions,
Yeah.
but it's not a deliberation, it's not a substantive discussion about the application. So that's the nuance with site visits. And the other thing, too, is typically they're on private property, right? So the public, unless the private property owner consents, the public is actually not allowed
Mhm.
to go onto the private property. So,
I have a question about your presence at certain decisions, and I don't think I got a chance to ask before, but we had a situation last year where at a certificate of appropriateness portion of the meeting, applicant brought an attorney,
okay.
and you had left because generally you don't stay for that. And I
Yeah.
guess, I don't think we felt that it was a particular concern, but my question was, if at some point we felt that an applicant brought an attorney and we didn't have the benefit of counsel, would it be appropriate if the chair decided to say, you didn't tell us you were bringing an attorney, we're feeling we're feeling as sort of like at a disadvantage without having the advice of counsel, we'd like to reschedule, and if you do plan to bring an attorney to certificate of appropriateness, it would be a courtesy to tell us in advance so
Yeah,
that
absolutely,
we could ask you
absolutely.
to be present for that kind of instance.
Yeah, you shouldn't feel pressured to take an action if you feel that you need advice of counsel before taking that action.
Yeah,
So it
well
would be
said.
appropriate to adjourn in that instance. And
I don't remember this one. Was it certificate of
This was on
appropriateness?
Highland Place. I guess it was, I don't know if it was in the second half of the meeting, but it was after the initial application had been rejected, and the applicant came back the following month with
With muscle?
engineer and an
They
attorney.
brought their muscle?
Yeah.
Okay. Public hearings, the planning board may hold public hearings in addition to those required by law when it deems such hearings to be in the best interest of the public or are required by law. Any matter for which a public hearing or information session is scheduled by the planning board should be placed on the meeting agenda. All public hearings need to be noticed?
absolutely,
Yeah.
yes.
That's what I thought.
Yeah, there's, the state law requires public hearings to be noticed in the newspaper, and then your local law requires further mailings
Yeah.
and sign notifications.
Doesn't say that here, but that's just part of our
That's in the
procedure.
code, yeah.
Yeah. Site visits may be conducted as a group or separately by individual members. Determination of whether a group site visit will be performed shall be made at a regularly scheduled meeting of the planning board. Site visits are limited to touring and obtaining factual information without substantive discussion. That's the key, concerning the merits of any application or other matter pending before the board. This is underlined. Members of the public are not allowed to participate in site visits unless it is on public property or the property owner invites the public to attend the site visit.
Hey, Jennifer, with regards to that one,
Yeah.
is there a limit to the number of members that can be at the site at a given time?
No, because the key is there's no substantive discussions about the application being had. I
Yeah.
mean, there can be a question and answer, but there should not be like deliberations and the type of discussion that we would have at a meeting of the planning board.
Okay, because I was always under the impression from other councils that you had to limit how many people you had, otherwise it was almost like you had to notice it as a meeting.
That's different, right?
If
Like, you
you-
can't have more than a certain number of members of the planning board gather informally, otherwise it becomes a, if you have a
Only if
quorum.
you're discussing business.
Substantive.
Okay.
So a meeting, under the open meetings law, quote-unquote meeting, is a quorum of the board gathering for the purpose of discussing business and actually discussing
Right.
business. So if you're, at a holiday party and there's, 4 of you there and you're talking and you're, how's the family, that's not a meeting. Even though 4 of you are present in the same place, you're not conducting business.
Okay.
But similarly, at a site visit, if you're just there to collect information and not have that deliberative discussion, it's been deemed not to be a quote-unquote meeting, so it wouldn't have to be noticed. I mean, the better way is to have less than a quorum go on the site visit, because then
No one
you
can-
don't have to worry about falling
can
into
accuse us, yeah.
a substantive discussion.
Yeah. Okay, so proceedings, the chair shall preside at all meetings of the planning board. In the chair's absence, the acting chair shall preside at the meeting. In the event the mayor has failed to appoint an acting chair, our acting chair is Randall.
Appointed
Or
by
is
the
that,
mayor?
I don't know if he was appointed. It's just been, that's how it's been for 20-something years.
Because I know that's typically who you choose, but I
Yeah.
don't remember there being a.
I don't know whether
appointment.
he's appointed. That's a good
Yeah,
question.
I don't think.
Or where such member is absent from the meeting, the chair shall select another planning board member to preside over that meeting. Yeah, typically, I don't know how it works out this way. If I'm not able to attend, usually Randall is.
Yes.
So, but if, I've
But I
also,
think Len, you had Len
Yep.
That's
Len
right.
covered.
do it one time
Yeah.
also, because Randall couldn't.
yeah, how did you like that? Was that fun?
It's okay.
Okay. So if it,
Did a good job.
I mean, I'm curious, any of you others who want a shot at it, if you would like to, let me know. On the off chance that my Randall or myself, obviously, Mr. Jensen has plenty of experience chairing meetings, so.
I think I relied on Jennifer to help me with order of business because I wasn't used to it like you are.
Yeah, okay. So it's rare that neither me nor Randall can attend, so. But in that case, yeah. I'll do the round robin via email. Anyway, all right, so let's see, what else, where are we? So notice, under New York State law, renoticing a public hearing is not required after the initial public hearing is held and continued to a specified date. Right, we don't have to renotice every month. However, the planning board and planning board attorney may require in his discretion the renoticing of a public hearing, including newspaper publication mailings and any other required public notice in the event of a long adjournment or for other reasons. In its sole discretion. Oh, okay. Am I doing this in order? Yeah. So before public comment, a formal presentation by the applicant and/or their representatives describing the subject proposal shall be made to the board and all others in attendance. The chair shall identify all correspondence pertaining to the application previously received from the general public and shall enter such correspondence into the record of the public hearing. We're usually pretty good about that. Written materials submitted by the public during the public hearing shall be given to the planning board chair and entered to the record of that public hearing. Copies thereof shall be given to all board members, city staff, and the applicant within 3 business days of the date. There's times when, if there's just a few, I'll read them. Otherwise, if there's quite a volume, I'll acknowledge them and then note that they are then therefore made a part of the record. And then, of course, available to the public on the city's website. No action shall be taken upon an application that is subject to a public hearing until such time as the public hearing has been closed. Motions. When a motion has been made and seconded and is under debate or discussion, no motion shall be received except to amend the motion, put the motion to a vote, adjourn or table it to a specified day, adjourn the meeting, or withdraw the motion. Any questions about motions? Voting. a majority of the whole membership of the planning board, including vacancies, abstentions, and any members disqualified, shall constitute a quorum. Therefore, a quorum of the 7-member planning board is 4 members.
Yeah, this is one that some people get confused with. It's not just a quorum of the members present, it's a quorum of the whole,
Full board,
full board, yeah.
always minimum 4.
Yep.
A quorum shall be necessary to take any formal action and to exercise any power, authority, or duty of the planning board. No member shall withdraw from a meeting of the planning board without permission of the chair. Aha. Can't get out of it. The chair of the planning board shall have the same right to act on matters before the board as other members, including the right to make and second motions. The ayes and nays of all board members' votes shall be recorded in the minutes. Disqualification, each member of the planning board shall vote on all questions before the board unless required to abstain in accordance with any applicable law or regulation for other valid reason. A member abstaining shall cite the reason for the abstention. And it's got to be a good one, not just, I don't feel like it. Any questions about that? Members shall be automatically disqualified upon a business interest or financial interest in the outcome of an application or other matter before the board, or for reasons specified in the Code of Ethics adopted by the City Council or the City of Beacon. Yeah, usually your recusal trumps any disqualification.
Right, if you have a conflict of interest
You're,
under Chapter 29, the
You're out
Ethics
there.
Code,
Yeah.
yeah, you're recusing yourself and you're not participating. Right.
all right, guidelines for comment at a public hearing. This is more for the public. Conduct of speakers. All persons speaking for the planning board shall conform to the following standards of conduct. Speakers must step to the podium to address the planning board. Before addressing the planning board, a speaker must give their name, address, and organization, if any, for the record. Speaker shall address all members of the planning board and shall avoid speaking at any one member directly or to the applicant or to the general public present at the meeting.
That's an important one that,
Mhm.
that I see violated a lot.
Yeah.
Not here, necessarily here, but elsewhere.
There's been some,
Yeah.
there's been
just-
some,
It's important that the speaker, you know,
Yeah.
the board is the audience, not the applicant, not other members of the
Or
audience.
one member of the board.
Exactly.
So we, as a board, should be kind of united in calling that behavior out if we see it.
Absolutely.
yeah,
It just helps keep the temperature at a nice level.
yeah. There've
not
been
at a
some feisty
heated level.
meetings in the past. We try to be respectful. A speaker's individual time to speak at a public hearing may not exceed 5 minutes. The chair may reduce such time to no less than 3 minutes if the chair of the planning board determines that an additional time limitation is appropriate due to the number of items on the agenda or the number of people present who wish to speak. Speakers shall observe commonly accepted rules of courtesy, decorum, dignity, and good taste. Any statements, comments, or remarks made by the speaker, 1, shall not concern the motives of a member of the planning board, and 2, shall not constitute a personal or political attack or criticism of any member of the planning board, or any officer of the city, any consultant of the city, any employee of the city or public. I'm looking at you, RA. Should any planning board member communicate with an applicant or its representatives or member of the public outside of a meeting, a member must place on the record at the next board meeting the fact that a communication took place, the persons with whom such communication was made, and the substance of the communication.
John, I think you
Just the
skipped.
page.
Oh, we did?
Yeah.
Oops. We're here?
That
Oh.
was the end of the.
Oh, sorry.
This is the end of the speaker guidelines.
Number 7, the audience shall be respectful of all speakers and shall refrain from comments and gestures such as clapping, cheering, or booing. Private discussions, sometimes we've had challenges with that too. Private discussions, cell phone use, or otherwise interfere with the meeting. Any speaker who fails to conform to their conduct to the rules provided herein shall be directed by the chair to cease speaking and yield the floor. The applicant and applicant's representatives shall be bound to the time limit set forth herein, but shall be allowed to speak for such time as permitted in the sole discretion of the chair. All right. Chair shall make all speakers aware of the guidelines for public comment. It's interesting. Sometimes when we have big applications and there's a ton of people and there's the chance that it'll get rowdy, we do read these rules.
We do, absolutely. And we should probably keep a copy of them on the podium for people to
Yeah.
reference.
Good idea.
Yeah.
I carry one around in my. Copies of the guidelines for public comment shall be made available to the audience of the meeting along with a copy of the agenda. Interested parties or their representatives not in attendance may address the planning board by written submission prior to the close of the public hearing. Debate or discussion between audience members and the speaker having the floor shall not be permitted. Debate or discussion with the speaker on the part of a member of the planning board, city attorney, city consultants, a guest at the planning board table, or any other city employee in the audience who has information pertinent to the discussion shall not be permitted, except in the chair's discretion. All right, so advisory opinions. The planning board may advise and make recommendations. Ooh, wow. 7:30. We can go through these quickly.
Yeah, I think probably the most important one of the remaining points is the one that you skipped to.
The one that I jumped
Which is
right
the
to?
communications that, planning board
Yeah.
members should refrain from having discussions with applicants or members of the public outside of this meeting about pending or future applications. And to the extent a conversation does happen, then that planning board member should, at the next meeting, disclose that for the
Disclose.
record and summarize what the discussion was.
Yeah.
But, those outside conversations should be avoided.
Yeah, and then in order to avoid the appearance of impropriety, potential applicants and their representatives shall communicate outside of public meetings with the planning board secretary, its consultants or attorney, rather than planning board members.
Right, so just like the applicants are not communicating directly with you
Yeah,
outside of regular meetings. Applicants can contact Mercedes, can contact Natalie, myself,
Yep.
John, but not the planning board members directly.
yep. And then number 11 just talks about recording of proceedings and meetings. Minutes, always kept by state law, required. And they're always on file and available to the public. And then we can amend these from time to time. I can't think of any reason why. We did amend them, I was going to say recently, it was 2018.
2018, yeah.
There's the video too, which is a complete record of the,
Right,
which is available to
Right.
everybody.
yep. Okay. Any other thoughts, questions?
Just a quick question about that, I think there's this comment, the planning board may advise and make recommendations to the city council relating to any subject matter. It doesn't have to be in response to a request for review. So if we felt collectively that a certain issue required attention, we could recommend it spontaneously, right? I mean, it's so, and I
Yes.
think we talked about this really briefly, but on the short form, like the EAF forms, there is a question, is this a National Historic Register site? Is this site been, discussed by the SHPO? We don't, and I don't know if we can modify that form. We can't, but we don't have a guideline saying, is this a city designated landmark building? So there are things that are like, if we
That
felt strongly
comes-
about
yeah.
something that we could change, we could make a spontaneous recommendation to the council.
Or it doesn't
that's
even
okay.
have to go to the council necessarily. That's something, like, if you wanted that line item, not necessarily in the short form EAF, but that could be a line item in, like, our site plan application form for an applicant to check, not just the address, section, block, and lot number, but there could be a question,
landmark.
is this in the HDLO, or is it a landmarked, site or structure under our local code? And that can just be done administratively, changing our forms.
Are you asking for the reasons of recording it, or, because usually
I just picked that as an
the
example.
applicant will disclose, or
It
it'll have
comes
been
up in
researched by
Natalie's
our
memos, yeah.
Doesn't always come up.
crack consultants.
It was just an off-the-cuff example, but I'm just saying, I think we should, maybe occasionally at the end of the year or something, we should think about any particular lessons learned we've had from different applications that might cause us to just recommend something and say, we've.
A year in review? Sure.
Can do it individually, too. Doesn't
And we
to
don't
be a
even
group
have to
effort.
wait until the end of the year
Yeah.
as something comes up. If it's something that we can handle at the consultant or staff level, we can do that
Yeah.
to correct course or
Usually
things more
best,
efficient.
best handled, yeah, as you say, in the moment,
Mhm.
because it's fresh. And then, yeah, we wouldn't necessarily want to do that at a meeting. We could take that offline even, yes?
Yeah, absolutely.
Because that's usually administrative.
Yeah.
Okay,